Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the 16th lecture of our course on law of copyright, patent, trademark and other IP. We started talking about trademark law. In the 15th lecture, I introduced some basic concepts of trademark, including the meaning of mark, trademark, meaning of certification mark, collective mark, what are the functions of a trademark, what do we mean by a mark used in the course of trade? And we also talked about the very fundamental concept of distinctiveness in trademark law. We said that a mark in question, in order to be registrable, must have the quality called as distinctiveness. That is, to distinguish goods and services of one trader from the goods and services of other traders. Now, continuing with whatever we discussed in the previous lecture, the present lecture is more about registration. It is on registerable marks. Some preliminary observations and then we will talk about the two important sections. One is section 9, which talks about absolute grounds for refusal of registration of a trademark, and section 11, which provides for relative grounds for refusal of registration of trademark. But before that, there are some preliminary observations. If you see, I have listed some 5-6 preliminary points which may be relevant, and with this background, we will go on to discuss the provisions. You see, under common law, a trader used to acquire right in a distinctive mark merely by using it upon or in relation to some goods. So, there was no mechanism that unless you register it, you won't be able to get protection. So, under common law, the mechanism was a trader, if he has a distinctive mark, he gets rights over his marks simply by using those marks in relation to some goods. Whereas in Trademarks Act 1999, the rights which a trader gets, a proprietor gets, is obtained by registration of a mark under Trademarks Act 1999. Keep in mind that property in trademark does not exist in vacuum. We also discussed, if you recall in the last lecture, that non-distinctive marks, for example, a descriptive mark, which is essentially a non-distinctive mark. Property in non-distinctive trademark can also be acquired by extensive use of trademark in relation to goods. This is a situation of acquired distinctiveness, if you recall. Similarly, there is another point which I would like to mention, that a trademark is registered for a limited period of time and it has to be renewed time and again. So, property in a trademark will be lost if registered trademark is not renewed. So, these are some of the preliminary observations, and be very clear that the Act does not define the categories of marks which are registrable. It only tells me what are the grounds for refusing the registration. It does not tell me what all are registrable marks. It only tells me what are the grounds for refusing registration. So, these are some of the preliminary observations. Now, let us talk about registration of trademark. As I already mentioned, that Act only tells me what marks are not registrable. It does not give me the list of registrable marks. There are two headings under which it tells me what marks are not registrable. One is absolute grounds for refusal of registration. The second is relative grounds for refusal of registration. The basic qualification for registrability of a mark as I mentioned in the previous lecture, is contained in the definition of trademark itself. That is, a trademark must have the capability of being represented graphically. It must have the capability of distinguishing the goods or services of one trader from another trader. So, we concluded that whatever mark which is not prohibited under section 9 or section 11 and which fulfills the requirements of graphical representation and distinctiveness will be eligible for registration. So, all the marks which are not prohibited here and fulfill these two requirements is eligible to be registered in the Trademarks Act. Now, this expands the scope of registrable marks. So, instead of identifying and giving a closed list of marks which are registrable, you remember we discussed section 13 of Copyright Act, in which we said that what are those works in which copyright subsists. We said that we have a close-ended list and therefore it is very rigid and there is little scope to go beyond whatever is mentioned in that list. Unlike section 30, in Trademark Act, we do not have a closed list. We have broad disqualifications. Whatever marks which are not prohibited by these broad disqualifications will be eligible to get protection here, will be eligible to get registration here, and therefore I said that this system expands the scope of registrable marks. It is easy to get into the list of registrable marks as compared to the situation where you are trying to get into the list of copyrightable works. So, any mark which is not prohibited and which fulfills the requirements given in the definition of trademark is eligible to be registered under Trademarks Act 1999. Now, let us first see what is there in section 9. Section 9, which provides absolute grounds for refusal of registration. You see, you have to understand this point very clearly, that absolute grounds for refusal are based on inherent qualities of the trademark. Refusal is not based on the possibility of confusion in market. You see, the relative grounds which are there in section 11 are there because use of those trademarks will create confusion in marketplace. Whereas absolute grounds are grounds of refusal because there is something inherently lacking in the trademark itself. So, that is the difference between 9 and 11. 9 will list those grounds which actually point towards inherent deficiency in the trademark itself, whereas 11 is pointing towards those aspects where the consequences lead to deception. Consequences of registration of those marks will lead to confusion. Now, coming back to 9, I said we are refusing because there is something inherently lacking in the trademark. For example, if the trademark is lacking in distinctive character, or if we are trying to register a mark which has become customary in the trade. If you see, I have identified 2 points. I said in section 9 we are refusing because the mark inherently lacks something. For example, it is lacking in distinctive character, or probably it has become customary in the trade. You see, there are 2 examples. These are the marks which are inherently not capable of being registered, not because these may cause confusion for customers. Now, let us see what all are prohibited. Section 9(1) gives you a list. 9(1)(a) is the first point. It says the trademark which is not capable of distinguishing the goods or services of one person from that of another person. We discussed it in the previous class. This is what I mean by distinctiveness. I mentioned it. This is what I mean by distinctiveness. We discussed it in detail in the previous lecture. So, if the mark inherently lacks distinctiveness by virtue of section 9(1)(a), such marks are not registerable. There are cases. In the case of the Imperial Tobacco Company of India Limited versus the Registrar of Trademarks 1977, the Calcutta High Court refused registration of the word Simla on the ground that it is a famous geographical place and should be left common for everyone to be used. It does not indicate any trade origin. It does not connect your goods with the trader. And therefore, the word Simla, according to court, lacks distinctiveness. However, this is also important. We are not refusing a geographical word simply because it is a geographical word. In some cases, a geographical name may be accepted for registration if there is no realistic connection with the goods concerned. See, if I am using the word Simla, people may relate the product with that geographical place. But if I use North Pole for, say, banana or anything, then it is difficult for somebody to relate the product with that geographical place. In that case, there is no reason to deny registration of such a word only on the ground that it is a geographical name. But ordinarily, geographical names may not be allowed, as it was held in the case of the Imperial Tobacco Company of India Limited versus the Registrar of Trademarks 1977, judgment of Calcutta High Court. So, the first point in section 9(1) was 9(1)(a), where we said it lacks distinctiveness. The second point in 9(1) is there in 9(1)(b), which says that the trademark only consists of such marks which indicate quality or other characteristics of goods and services. You see, we discussed this word in the previous lecture. Descriptive marks are not registerable. The more apt a word is to describe the goods of a manufacturer, the less apt it is to distinguish them from the goods of others. So, better a word describes your goods, lesser are the chances for that word to be considered as a trademark fit to be registered. 9(1)(b) prohibits registration of marks which are descriptive, which identify the characteristics of the products or services. A mark is descriptive if it provides or gives information directly. Any indirect reference will not be sufficient to disqualify that mark as a descriptive mark. So, the reference to the product must be direct one. Mere suggestive reference is not sufficient. And there are few examples if you see here. I said in 9(1)(b), descriptive words are denied registration. But at the same time, we have to keep in mind that these words must describe the product directly. A suggestive reference would not be sufficient. Now, let us see what are the examples. The word radiation was to be registered for gas stove, and one cannot argue that you have radiations coming out of the gas stove which help you in cooking, and therefore radiation describes the quality. Court said it is not descriptive. Radiation is fit to be registered for gas stove. Next is, there is a word motorine for lubricating oils, and it was opposed on the ground that it somewhere indicates that it is a lubricant oil for motor. So, it may be an invented word combining suffix, prefix from two different words, but it indicates that it is a lubricating oil for motors. But court considered it to be non-descriptive. Another example is perfection. Perfection word was to be registered for soap. Court said that it is a laudatory word. Only your soap is perfect. Others' soap is not perfect. This is not acceptable. Usually laudatory words are not allowed to be registered. Another example is orlvula. Orlvula. Court says this is descriptive. How? Because it sounds like all wool. Although if you look at this word, it appears to be an invented word containing orl, which does not give me any meaning, vula, which does not give me any meaning, but if you pronounce it, it is pronounced as orlvula, which is an indicative of the characteristic of the product which is going to be used. It is all wool, and therefore it is described as a descriptive word. Another example I have mentioned is the word charm for ladies' stockings. Court said this is direct reference. So that is how we have to understand whether the word in question directly refers to the quality of the product or whether it is only a suggestive reference. So these are the examples. Radiation was allowed for gas stove, motorine was allowed for lubricating oils, perfection, a laudatory word is not allowed, orlvula on the basis of the way you pronounce it, not allowed, charm for ladies' stockings, it is a case of direct reference. So therefore, if you go back 9(1)(a), keep in mind 9(1)(a) is a ground where the mark lacks distinctiveness. 9(1)(b) talks about those marks which are descriptive marks, and there are more examples in Messrs Hindustan Development Corporation Limited versus the Deputy Registrar of Trademarks. It is an old case of 1955. The word rasoi was to be used for edible oils, and according to court, such mark indicates the nature of the product because you are using edible oils in rasoi actually. So therefore, there is direct reference according to court, and the registration of rasoi for edible oils was not allowed. Another case, Central Camera Company Private Limited versus Registrar of Trademark. You see, this is the product, this is the mark. Solar undoubtedly refers to the sun and understood to be produced by or coming from the sun as solar energy. This was held to be a direct reference to the character or quality of the goods, thus not registrable. This has to do with radiation. Court read direct reference, and therefore registration was denied. This is about descriptive marks. The important thing to be kept in mind is it must make a direct description. The reference must be direct. Only suggestive reference will not be sufficient. So we understood 2 points in absolute ground of refusal, 9(1)(a) where the mark inherently lacks distinctiveness, 9(1)(b) where the mark in question is nothing but a descriptive mark. The third is there in 9(1)(c). The trademark has become customary in the current language or in a bona fide or established practice of trade. It has become customary in current language. It has become customary in current language. Words which have become generic words, which have become publici juris, which have become generic words, or which are words common to a trade. These words cannot be registered. Why? Because these words belong to public at large. So generic words are not registrable. Words which have become publici juris are not registrable. There is a case here, SBL Limited versus Himalayan Drug Company, 1997. This case relates to an infringement action filed against the respondent, where the allegation is that the trademark of appellant is Live 52, and this trademark of appellant was used by the respondent as Live T. But this argument was dismissed by the court on the ground that live, the portion of this mark, live 52, that is live, is publici juris. It is a generic word. It is a word common to all. Live is considered as a generic on account of the fact that it is used in respect of medicine used for treatment of ailment of liver. So almost most of the drugs which are used for treatment of liver ailments will be using this word live in that trademark. It is common to all and therefore it is not distinctive part of the trademark. So in the trademark live, the claimed trademark live 52, court declared that this part live is not the distinctive part of the trademark because this is nothing but liver and which should be common to all. It's a publici juris. The division bench of Delhi High Court held that nobody can claim exclusive right over the use of any word, abbreviation or acronym which has become publici juris. Now this is the law which I am trying to explain. Nobody can claim exclusive right over the use of any word, abbreviation or acronym which has become publici juris. So therefore any word which is customary in the current language, any word which has become generic word, any word which has become publici juris cannot be monopolized by any trader, it cannot be registered as these words belong to the public at large. Another point relevant here is, this is called, because first part we saw that the word itself was a generic word, therefore it is not fit to be registered. The second is about loss of distinctiveness. Loss of distinctiveness. The first part we discussed was where the word is not distinctive. Why? Because it is a generic word. In the second part, I am referring to a situation of a word which was originally distinctive, has lost its distinctiveness. It says that distinctiveness may be lost by becoming a generic name. There are several instances where a unique brand, unique words, for example, celluloid, it's a unique word. But this word celluloid has become common household name. And if a word becomes a generic word, then it can no longer be recognized as a registered trademark. Try and understand. A generic word cannot be a trademark. A generic word cannot be registered as a trademark. A registered trademark, if that mark becomes a generic word, it will lose its registration. For example, if people keep on saying that, take any word which is becoming generic, as I mentioned in the previous class, suppose there is this Dettol initially, and it is a distinctive word, but if we start using this word for any antiseptic liquid, if we start using this word for any antiseptic liquid, it means Dettol has lost its significance and it has become a generic word. If we start using the word Xerox, for example, for photocopying, that means Xerox has lost its distinctiveness. If we start using surf for any detergent powder, it means that word surf has lost its distinctiveness, it has become generic word. So there is always a threat that a trademark, because of extensive use, may become a generic word, and in that case there is a possibility of loss of distinctiveness and accordingly the registration may be cancelled. So this is the third point. First was distinctive, it lacks distinctiveness. Second is descriptive words cannot be registered as trademark. Third is the words which may be called as generic words cannot be registered as trademark. We refer to the case of SBL Limited versus Himalayan Drug Company, where Liv 52, this mark out of this Liv part was declared by the court to be generic, and therefore it cannot be monopolized by one trader. This section is not only applied to words, it is also applied to color combinations. Let us see how. Certain color combinations also become generic. For example, in the case of Colgate Palmolive Limited versus Patel 2005, Delhi High Court held that red color, red and white combination are common to the toothpaste trade. So, therefore, you cannot register the combination of color as red and white for your toothpaste. This combination of color is common to the toothpaste trade in domestic and as well as international market, and therefore cannot be monopolized by any party. So, therefore, the disqualification of generic word is also applicable to color combinations also, and we saw this example in the case of Colgate Palmolive Limited. There is another case which I may refer, it is EI DuPont versus Gemini Distillers 2004. Somebody wanted DuPont to be registered as a trademark. It was opposed that it is a surname in some countries. Court allowed registration of this word DuPont here on the ground that it is a very rare surname in India, and because it is a very rare surname in India, it is not a kind of general word, and therefore it has this capability of distinguishing the goods of the claimant from goods of other traders. Now, so therefore there are 3 points which are discussed: lack of distinctiveness, descriptive word, generic word. A trademark shall be registered if before the date of application for registration such trademark has acquired a distinctive character by its usage or it being a well-known trademark. I mentioned this point in the previous lecture also. This is there in the proviso of section 9(1). It says that any word which is originally not distinctive, which may be originally descriptive, which may be originally a generic word, may still be registered as trademark if it acquires distinctiveness. We discussed the meaning of this term acquired distinctiveness. If you remember, I said the words lose their primary meaning and acquire a secondary meaning. And such words which acquire distinctiveness may be registered. This case may be useful. Shalimar Chemical Works versus Deputy Registrar Trademark. This is 2012. Chef was claimed with respect to spices, edible oil, edible products, and it is clear that there is reference here, and the reference is not only suggestive. The mark which was claimed in registration was chef, and it was claimed in registration for spices, edible oil, edible products, but still in Shalimar Chemical Works versus Deputy Registrar Trademark, this word was allowed registration on the ground that it has acquired special distinctiveness by way of widespread sale and promotional activity. This is important. This is a descriptive mark, it is a generic word. It describes the product or services to be sold under this name. It was still allowed registration because the case was covered in the proviso to section 9(1), where court said that because of widespread sale and widespread promotional activities, we can say that the word chef has lost its primary meaning with respect to this case. It has lost its primary meaning and has acquired distinctiveness. So, whenever we listen this word chef, we will have this tendency to relate this word to the products on which it is applied and not to a chef wearing a hat. The another case, an important case of 1972 Delhi High Court is Jeep Flashlight Industries Limited. Jeep Flashlight Industries Limited versus the Registrar of Trademark. This is a case in which an application with respect to the word janta was there with respect to electric torches. So, the goods are electric torches and the claimed trademark is JANTA, Janta. So, this is the trademark which was claimed in relation to these goods. And it was argued that Janta has a dictionary meaning as people, and therefore, this does not have any direct reference to the quality of the goods on which it is to be used. There is no direct reference. People, the word people has nothing to do with electric torches. Whether in English or in Hindi, people or janta, it has no direct reference to the character and quality of the goods. But the registrar held that it has direct reference. Registrar held that it has direct reference. Why? Because registrar held that goods bearing such a name, janta, indicate that they are cheap in price and meant for common people. This makes some sense. Any service with the word janta tends to indicate that it is cheap in price and it is meant for common people. And in fact, the torches sold by the company were the cheapest in the market. So, that further substantiated the point which the registrar held. The Delhi High Court held that despite the logic taken by the registrar, Delhi High Court came to the conclusion that mark does not indicate the character or quality of the goods. This is one part. The word janta, according to registrar, indicates that the product sold under this trademark are cheap products and are meant for common people, whereas the court held otherwise. But what became the basis for judgment is, according to court, janta is a generic word. It is a word of common use. And if it is a word of common use, it does not have inherent distinctiveness. It was argued that by reason of extensive use of the mark janta, it has come to denote the goods of the applicant to the traders and dealers. They are trying to prove that by extensive use we have acquired distinctiveness. The word janta has acquired distinctiveness. But court held that the word janta in India is used widely to denote common people and that it is one of those words which should be kept open for the use of any person for bona fide training purposes. This is how the third disqualification, that a generic name cannot be a trademark, is applied. Section 9(2), following trademark shall not be registered if such trademark is likely to deceive the public or can even cause confusion. In the case the Leather Cloth Company Limited versus American Leather Cloth Company Limited 1863, the plaintiff had stamped upon their goods the words tanned leather cloth, whereas only about 1/3 of their whole produce was in tanned cloth. It was held by House of Lords that plaintiffs were not entitled for registration of their trademark. So, if the trademark is likely to deceive the public, it cannot be registered. If the trademark is hurting the religious sentiment of any class or section of Indian citizens, it cannot be registered. For example, the use of names or device of deities on footwear will be considered disrespectful. We have a case, Amritpal Singh versus Lal Babu Priyadarshi 2005. The word Ramayan was refused registration on the ground that Firstly, it was not capable of distinguishing the goods of the applicant from other traders' goods, and secondly, it was likely to hurt religious sentiments of a class of society. So, therefore, under section 9(2), a trademark is not registrable if it is likely to deceive the public. A trademark is not registrable if it is likely to hurt the religious sentiments of any class or section of Indian citizens. Third point is, if such trademark contains any kind of scandalous or obscene matter, such a trademark is not registrable under section 9(2). For example, a mark which is contrary to the morality or is considered obscene must not be registered, and the onus will be on the applicant to prove that it is not scandalous or obscene. In a trademark application, the registrar refused the registration on the ground that the mark was contrary to accepted principles of morality. The appellate authority concluded that this trademark would cause greater offence than mere distaste to a significant section of the public. So, if a mark contains things which are scandalous, which are obscene, such a mark cannot be registered under section 9(2). Registration of a mark is also prohibited under Emblems and Names Prevention of Improper Use Act 1950. This Emblem and Names Prevention of Improper Use Act 1950 prohibits the improper use of certain emblems and names for professional and commercial purposes. Section 4(b) of the Act prohibits the registrar from registering a trademark or a design which holds any emblem or name, and use of it shall be in contravention of section 3 of the Act. For example, national flag cannot be used as a trademark. So, therefore, any mark which contains obscene matter, any mark which is prohibited under Emblem and Names Act 1950, these marks are not registrable. According to section 9(3), there are certain marks which are not registrable. A mark shall not be registered if it consists exclusively of, in combination. It does not say that it comes in combination of all these. It only says if it consists exclusively of these. What are the three things? Shape of goods which result from nature of goods themselves. You have an example, shape of an egg tray. The shape of an egg tray, the sole purpose is to hold eggs, and this would not be considered as capable of distinguishing from others. So, any mark which is nothing but a shape of goods which result from the nature of goods themselves is not registrable. The next point is a mark which is a shape of goods which is necessary to obtain technical result, Shape of the goods which is necessary to obtain technical result, such shapes cannot be registered. Shape of a square pinned plug. If the pins are not square, they will not fit into the standard socket. Therefore, it is mandatory to achieve that standard shape, which is a technical result. So, therefore, shape is there to achieve some technical result. Such shape cannot be registered as a trademark. Third, the shape of goods which add substantial value to the goods. For example, shapes which are more effective than other alternatives for performing a particular task, add substantial value to the goods, are not registrable. So, we saw what all are not registrable in 9(1), clause A, B, C, generic words, descriptive words, words which lack distinctiveness. We saw what is not registrable in 9(2). We said it should not be obscene, it must not be prohibited by Emblems and Names Act, it must not hurt religious sentiments, it must not be deceptive, it must not cause confusion. These are prohibited under 9(2), and 9(3). We saw what is prohibited, what are prohibited shapes. That's all in section 9, which talks about absolute grounds for refusal of registration. I already mentioned that these absolute grounds of refusal of registration are because of something inherently lacking in the mark, whereas section 11, which talks about relative grounds for refusal of registration, are there not because the mark inherently lacks something. It is not that the mark is a generic word. It is only that the mark, if registered, may lead to confusion, may lead to deception. So, it is because of those aspects that you have certain grounds for refusal of registration of a trademark. It is there in section 11 of Trademarks Act 1999. If a mark confuses public on account of the mark being identical or similar to an earlier trademark, the same won't be allowed for registration. So, my mark will be refused registration if it is similar to a mark already registered. Various grounds which are listed in section 11 are relative grounds, and as I said, these grounds are there because there exists a likelihood of confusion on the part of the public. The problem is, people may relate your mark with an earlier mark due to. These are there in section 11. I am not allowed to get my mark registered by virtue of section 11. Why? Because of its identity with an earlier trademark. It is similar to an earlier trademark. Not only identical to an earlier trademark, not only identical to an earlier mark, the goods are also similar. So, identical mark for similar goods cannot be registered. A mark which is identical to an earlier mark for similar goods will not be registered. Second, similarity to an earlier trademark and identity or similarity of the goods. My mark is not identical to your mark, it is similar to your mark. Identical means exact copy. If my mark is identical to your mark, my mark will not be registered even if the goods are not identical but only similar. So, identical mark for similar goods not allowed. Similar marks for identical goods or similar goods not allowed. So, therefore, there are two refusals: identical mark and similar mark. So, if my mark is identical to some earlier mark, it cannot be registered for similar goods. If my mark is similar to some earlier mark, it shall not be registered for identical goods or similar goods. This is what you have in section 11. We will go ahead, we have more. So, basic thing is section 11 gives you relative grounds of refusal because there is a chance, there is a risk of confusion, not because something is lacking in my mark. A trademark shall not be registered if or to the extent the earlier trademark is a well-known trademark in India, and the use of later mark without due cause would take unfair advantage of or be detrimental to the distinctive character or repute of the earlier trademark. Go back to the previous slide. What all are not registrable? If my mark is identical to your mark, even it is identical to your mark, it is not allowed for similar products. If my mark is similar to your mark, it is not allowed for identical or similar products. But this is crucial, this is important. If my mark is identical or similar to an earlier trademark, that earlier trademark is a well-known trademark. If it is identical to earlier mark and the earlier mark is not a well-known trademark, it is prohibited if the goods are similar. If it is similar to an earlier trademark but the earlier trademark is not a well-known trademark, then it is prohibited for similar goods or identical goods. For dissimilar goods, you can have registration. For non-identical goods, you can get it registered. But here in this case, if my mark is identical to an earlier trademark or similar to an earlier trademark, and that earlier trademark is a well-known trademark, then registration will not be allowed even for dissimilar goods. Even for dissimilar goods, which is to be registered for goods or services which are not similar to those for which the earlier trademark is registered in the name of a different proprietor. So therefore, this clearly indicates that we have a better protection for well-known trademarks. So identical with an earlier trademark, not allowed for similar goods. Similar with an earlier trademark, not allowed for similar goods, identical goods. But if the earlier trademark which I am referring to is a well-known trademark, then registration will be refused for similar goods, identical goods as well as dissimilar goods. A higher protection is given to well-known trademarks. We will see what is the meaning of well-known trademark. Some additional grounds are there in section 11.3. If the trademark registration is prevented, one, by virtue of any law, in particular the law of passing off protecting an unregistered trademark, or if registration of trademark is prohibited by virtue of copyright, then such trademarks shall not be registrable. So we saw what all are not registrable trademarks in section 9.1, 9.2, 9.3. We also saw what is not registrable in section 11.1. 11.2 specifically talks about well-known trademark because it says that when you registered a mark similar to well-known trademark, even for dissimilar goods, it would cause taking unfair advantage to the reputation of well-known trademark, or it will be detrimental to the reputation of the well-known trademark. So therefore, well-known trademarks are given better protection. Let us understand what do we mean by well-known trademark. Well-known trademarks have their goodwill and reputation protected across the nation and across categories of goods and services. There is no condition here. It is protected across the categories of goods and services. For example, Google has been registered as a well-known trademark of Alphabet Incorporated, which thereby means only Alphabet Incorporated can register the term Google for any category of goods and services. This is what we mean by well-known trademark. Even if the service is not related to the internet industry, no other company but Alphabet Incorporated can register Google as its trademark. So it is not that you are allowed to use this trademark Google for, say, selling shoes. No, you cannot do that. You cannot use this mark even for unrelated, dissimilar products. That is the importance we give to well-known trademarks. Section 2.1 ZG defines well-known trademark as a mark which has become so to the substantial segment of the public which uses such goods or receives such services that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between those goods or services and a person using the mark in relation to first mentioned goods and services. So any activity which may lead to dilution of trademark, tarnishing the image of a well-known trademark is not permitted under the Act. Section 11.2 provides for protection of well-known trademarks across all classes. The provision of this section extends the ambit of protection provided to the well-known trademarks. According to this clause, well-known trademarks are to be recognized and protected across all the classes of goods and services. So therefore, a trademark which is identical with or similar to an earlier trademark and is to be registered for goods or services which are not similar to those for which the earlier trademark shall not be registered if or to the extent the earlier trademark is a well-known trademark in India. That is the point which I already explained. You are trying to register a trademark which is either identical to or similar to an earlier trademark, and such registration will be refused even with respect to goods and services which are not similar, provided this earlier trademark is a well-known trademark in India. Because allowing use of later trademark by the proprietor would mean taking undue advantage, unfair advantage of the reputation of well-known trademark, and shall be detrimental to the distinctive character or repute of the earlier trademark. How do we decide whether a particular mark is a well-known trademark or not? What are the criteria to determine a well-known trademark is a well-known trademark or not? Section 11(6) talks about it. The first factor is knowledge about the mark in relevant section of the public. Now, this is very subjective. How well should a mark be known to be called as well-known trademark? It's very subjective. So, knowledge about it. Second, the duration, extent and geographical area in which the trademark is used. Third, the duration, extent and geographical area in which the trademark is promoted with respect to goods and services to which it applies. Fourth, registration or application for registration of the trademark to the extent they reflect the use or recognition of the trademark. Fifth, which is very important, the record of successful enforcement of the rights in that trademark, including the record stating that the trademark has been recognized as well known by any court or registrar. So, what is whether you are diligent enough and taking proceedings to the court so as to enforce your rights in those well-known trademark is also an important factor. If you keep on avoiding or ignoring the acts of infringement that may go against your mark being called as well-known trademark. Certain conditions which are not important to be considered while deciding whether a mark is a well-known mark or not. Section 11, subsection 9 specifically mentions certain conditions which need not be required for the purpose of granting a well-known trademark. These conditions are whether the trademark has been used in India, it may not have its presence in India, that's very clear. Whether it is in use in India or not is not a relevant consideration. Whether the trademark is registered or not is not a relevant consideration. Whether the application for registration of trademark has been filed in India or not is not a relevant consideration. Trademark is well known in or registered in any other jurisdiction other than India, this is not a relevant consideration. Whether it is registered in some other country, whether it is declared as a well-known trademark in some other country or not. The trademark is well known to the public at large is not a relevant consideration. As I mentioned, how well a mark should be known to the public to be called as a well-known trademark. It should actually be well known to public, that's not an important consideration. So, these are some of the factors which need not be taken into account. Generally, people tend to believe that a mark should be thoroughly well known in India in order to be called as a well known. Generally, people tend to believe that a mark must be registered, an application at least must be pending, it must be a well known declared in some other country, but all these factors are of little use. It can be stated that for a trademark to be granted protection in India, it is not necessary that the mark owner has its business in India or its trademark is registered within India. Nor is it required that trademark is known to the masses as a whole. There can be trans-border reputation. There may not be any presence in Indian market. The mark may not be registered in India. Mark may not be known to the masses. Masses may not know about Rolls-Royce. It still remains a well-known trademark. So, the particular provision provides for concept of trans-border reputation, which I mentioned. Even if there is no presence of that mark in India, it still can be called as a well-known trademark. So, if we conclude this lecture, we understood the grounds for refusing registration in the present lecture, the absolute grounds under section 9 and relative grounds under section 11 provide the complete list of objections. As I already mentioned, we do not have a list of registrable marks, we only have list of prohibitions. Thus, if the objections are not sustainable and the mark qualifies to be called as a trademark according to the definition, it is fit to be registered. The provision on special protection for well-known trademark was also discussed. In the next two lectures, we will discuss about concept of infringement of rights and remedies for passing off. So, that is all in section 9, section 11, that is registrable marks. Thank you very much for joining. Next section will be on infringement of trademark. Thank you very much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I will be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samara. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samara and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samara to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samara. See you in the next episode of Literary Snippet.